What is guardianship? Guardianship is when an individual petitions the court to say so-and-so is incapacitated. They could be asking to have the court determine that individual to be fully incapacitated, meaning unable to make any medical or healthcare decisions. The court may remove their right to vote, the right to marry, the right to do estate planning documents, the right to determine their residence, the right to determine healthcare. We don't like to have to do a guardianship, ever. We always look for the least restrictive alternative, always. And the way to have a lesser restrictive alternative when somebody loses capacity is to have appropriate documents in place that allow your loved ones to take over in making decisions and assuming responsibilities so that you do not have to go to guardianship court. If you do not have a power of attorney, a healthcare surrogate in place, there is a very high likelihood with a disease that might involve dementia, that if you get dementia, that you're going to end up in guardianship court, because that will be the only way your loved one will be able to step in and get a withdrawal from your IRA, or get access to individual assets that are not jointly held, or to make a decision about placement, particularly if placement involves placement in a secure facility with someone who has wandering tendencies due to dementia. So you really want to avoid a guardianship. The most uncontested guardianship is probably going to cost $6,000 to $8,000 in legal fees at a minimum. And if it's a contested guardianship, you can run into the tens of thousands of dollars.